So, have you ever really stopped to think about what stops a government from just doing whatever it wants? In the UK, the answer isn't some big, fancy document. It's an idea, a powerful idea called the rule of law. And in this explainer, we're going to pull back the curtain on this invisible blueprint that shapes everything the state can, and maybe more importantly, what it can't do. Right, let's just put the big question right out there. What's the barrier? What are the guardrails? The answer, as you'll see, isn't a person or a single piece of paper, but this really powerful, deeply embedded concept. And to get our heads around it, we've got to go back to the original design. And when we talk about the original design in the UK, we're talking about one person in particular, the constitutional scholar A.V. Dicey. You can think of him as the original architect. His work basically laid out the classic blueprint for how a state should operate under the law. Let's stick with that blueprint idea for a second, because it's a really good one. The rule of law is like the master plan for building a country. It sets out the foundations, the support beams, and the absolute limits, making sure that power is used within a clear, predictable framework, not just based on the whim of whoever's in charge. Okay, so Dicey's blueprint really comes down to three huge ideas. First, the supremacy of law. This means the government can't just punish you out of the blue. There has to be an actual pre-existing public law you've broken. Second, equality before the law. This is massive. It means everyone, from you and me to the prime minister, has to play by the same rules. And third, our rights. They don't come from one big constitutional document. They've been built up brick by judges making decisions in real cases over hundreds of years. And look, this isn't just dusty old legal theory. These principles were forged in the heat of real-life legal battles. The idea that the state can't just barge into your home, that was hammered out way back in the 1700s. And the principle that no government official is above the law, well, that was proven pretty dramatically when a Home Secretary was found to be in contempt of court for ignoring a judge's order. This is the rule of law in action. All right, so we've got the foundational principles from Dicey. But who actually builds the structure day to day? Well, the first key player in our blueprint is Parliament. If the rule of law is the overall plan, you can think of Parliament as the chief architect, the one drawing up all the specific rules. Now, Parliament's most critical job here is to get things right from the very beginning. By creating laws that are clear, that are public, that are predictable, it builds a solid framework for the government to work inside of. It's like building strong, straight walls from the outset. It's really the first line of defense in upholding the rule of law. So, if Parliament is the architect that writes the rules, who makes sure the government actually follows them? Who's the inspector on the building site? Well, that is the absolutely vital job of the courts. They are the guardians of the blueprint. And the main tool they use is something called judicial review. Now, it's really crucial to get this part. This isn't about judges deciding if they agree with the government policy. They're not asking, was this a good decision? They're asking, was this decision made lawfully? Did the government have the power to do this? It's basically a quality control check on the process. And this table here breaks down the three main things a judge will look for. First, was there illegality? Did the government act beyond the powers Parliament gave it? Lawyers have a fancy term for this, ultra-virus. Second, was it irrational? Was the decision so completely bonkers that no sensible person could ever have made it? And third, was there procedural impropriety? Basically, did they follow the right steps and act fairly in the process? But, and this is a big but, Dicey's blueprint was drawn up in the 19th century. The world has gotten a lot more complicated since then, and the sheer size and complexity of modern government have thrown up some major challenges to his nice, simple design. I mean, look at the difference. Dicey imagined this clean world of clear laws and ordinary courts. What do we have today? A massive administrative state. Countless agencies, public bodies, and tribunals, all making detailed rules and decisions using these huge, sweeping powers that Parliament has given them. It's a whole different ballgame, and it puts that original, elegant blueprint under some serious strain. And because of all this new complexity, the blueprint needed a serious update, a major renovation, you might say. And that came with the Human Rights Act in 1998. This was a game changer. It basically forced public bodies to justify why they were limiting people's rights, and it gave courts powerful new tools to check laws against a human rights standard. It created this formal conversation between judges and politicians about our most basic freedoms. And that conversation brings us right to the heart of it all, to the biggest, most fundamental tension in the entire UK Constitution. This is the ultimate clash of two massive core principles. It really boils down to this one huge question. What happens when the unstoppable force, which is parliamentary sovereignty, crashes into the immovable object, which is the rule of law? And here's the conflict, right there in black and white. On one side, you have parliamentary sovereignty, which says Parliament is the top dog. It can make or unmake any law it likes. But on the other side, you've got the rule of law, which says that all power, even parliaments, should be bound by some fundamental ideas of justice and fairness. So, which one wins? Well, the UK's answer is actually pretty clever. It's not a knockout blow for either side. It's more of a political conversation. Technically, yes, Parliament can pass a law that goes against rule of law principles. But, and this is key, the courts will basically force them to do it out in the open, using crystal clear, unmistakable language. This means Parliament has to stand up, own the decision, and face the music politically. You know, this whole discussion kind of forces us to zoom out and ask a much bigger, more philosophical question. What's the ultimate point of the rule of law anyway? Is it just about having a tidy set of rules, or is it about having the right kind of rules? Okay, so there are two big schools of thought here. The first is the formal view, often linked with the thinker Joseph Raz. For him, the rule of law is all about the process. As long as the laws are clear, public, and applied fairly to everyone, then the rule of law is doing its job. Whether those laws are morally good or bad, well, that's a separate political debate. But then you have the other side of the coin, the substantive view, argued really powerfully by Lord Bingham. He said, hang on, that's not enough. For the rule of law to actually mean anything, the laws themselves have to be good. They have to protect fundamental rights. They have to promote justice. A perfect process isn't worth much if the result is unjust. This table lays out the difference perfectly. For Raz, the formalist, law is like a sharp knife. It's a neutral tool. It can be used by a surgeon to save a life or by a murderer to take one. The rule of law just makes sure the knife is sharp. For Bingham, the substantivist, law is a tool specifically designed for justice. Its content, its moral purpose, is everything. So, which path does the UK system actually take? Well, in reality, it doesn't just choose one. It kind of does both. It weaves them together. It demands the clear, predictable, formal rules that Raz talked about, but it also animates that system with a deep concern for rights and justice, which is the heart of Bingham's substantive view. And really, that's the big takeaway here. The rule of law is not some dusty old idea sitting on a shelf. It is a living, breathing principle. It's the ongoing, day-to-day negotiation, the constant push and pull between the power of the state and the liberty of the individual. It's what makes sure we have a government of laws, not just a government of people. And that leaves us with one final thought to chew on. Is this blueprint, this rule of law, something fixed in stone, a permanent anchor for the state? Or is it more like a living guide, a map that each generation has to reinterpret and redraw to face the new challenges of its time? That's a debate that is very much alive.